Hello everyone, my name is Eric Sanchez. This is GPSV 365 and today I'll be discussing judicial lawmaking while focusing on Obergefell versus Hodges. In Obergefell, the Supreme Court essentially revises same-sex marriage laws across the entire country. Together in an encompassing understanding of how judicial lawmaking was used in Obergefell, it is important to understand the Supreme Court, their responsibilities, and important case law that paved the way for judicial lawmaking. And furthermore, I'll discuss the pros and cons of judicial lawmaking. Article 2 of the United States Constitution, known as the Appointment Clause, empowers the President to nominate and with the confirmation of the United States Senate to appoint public officials, including justices of the Supreme Court. The President has the legal authority to nominate whoever they want to serve in the Supreme Court. Almost always, they will nominate a justice that has historically ruled in favor of the political leaning of the president that nominated them. And furthermore, the Senate has the power to reject or confirm a nominee. The Constitution sets no qualifications for service as a justice. Therefore, the president may nominate anyone they wish to serve in the Supreme Court, and the Senate may not set any qualifications or otherwise limit who the president can nominate. Once confirmed, a Supreme Court justice is a member in a ninth court that has a lifetime appointment. The United States Supreme Court is the head of the judicial branch and the highest federal court in the country. As one of the three branches of government spelled out in the U.S. Constitution, their jurisdiction covers federal court cases and any state case that has a nexus to the U.S. Constitution. The chances of reaching the Supreme Court are very minute. The court is asked to review more than 8,000 cases every year. However, they only usually accept around 60 to 70 of those cases. The cases that make it through are very, very important. Since 1925, the 9 justices who make up the court have held the power to decide which cases they hear. Since then, cases must be met with certain criteria to be heard by the court. It must pose a substantial question of federal law. There must be a genuine dispute, and there must be a legal remedy that falls within the power of the court. Article 3 of the Constitution implies that the power of the judicial review, since it states the power of a Supreme Court shall extend to disputes under the Constitution and the laws of the nation. Judicial review is the term given to the court's power to review legislation that potentially conflicts with either federal law or the Constitution, including any of the 27 amendments. When the Founding Fathers wrote the Constitution, they hoped to ensure the court could act as a part of the system of checks and balances on the other two government branches and, of course, on all the states. Creating a strong central government like the one we have in America has its benefits, but also potential dangers. So it's important to include a powerful court that creates balance so that the executive or legislative branches don't overstep their legal authorities or violate the Constitution. The Mabry versus Madison Supreme Court decision confirmed that not only was the Constitution superior to pretty much all other legislation, but that if there was a doubt about whether laws were in conflict with the constitutional provisions, it was the Supreme Court's role to adjudicate. In the ruling, John Marshall declared that, quote, "It is emphatically the province and duty of the judicial department to say what the law is." And one last thing I wanted to briefly touch on prior to moving on to Obergefell versus Hodges is the Equal Protection Clause of the 14th Amendment to the Constitution. The Equal Protection Clause was ratified post-Civil War in 1868, and it was intended to stop government discrimination against Black Americans. However, this clause within the 14th Amendment protects us from the government in many other ways as well, as it firmly states that no state shall deny to any person within its jurisdiction the equal protection of the laws. It is important to note two key items in the wording of the clause, which are no person and no state. This wording is especially important in Obergefell versus Hodges. So moving forward to Obergefell versus Hodges. In Obergefell, the Supreme Court ruled that the fundamental right to marry is guaranteed to same-sex couples by both the Due Process Clause and the Equal Protection Clause of the 14th Amendment of the Constitution. The Supreme Court ruling requires that all 50 states and D.C. perform and recognize marriages of same-sex couples on the same terms and conditions as the marriages of opposite-sex couples, with all the accompanying rights and responsibilities. Prior to this ruling, individual states could decide whether they would allow same-sex marriage, and same-sex marriage in one state did not necessarily transfer to the state that did not allow them to get married in the first place. The two questions surrounding the case that the Supreme Court asked when deciding this case were: 1. Does the 14th Amendment require states to issue marriage licenses to same-sex couples? And question number 2, are the states required to recognize lawful out-of-state marriages of the same-sex couples? The Supreme Court decided yes on both questions. Furthermore, the court decided that same-sex couples have the constitutional right to marry under the 14th Amendment, and that marriage must be recognized across all states. So there's a Congress that makes laws, then what is judicial lawmaking? Well, the simplest ways to explain, Dr. J. Abraham says, quote, "It is simply a fact of life that in the United States, all social and political issues sooner or later seem to become judicial," end quote. And to me, this translates to say that in the pursuit of true justice in the United States, that oftentimes we meet social and political issues affecting Americans. And when state or federal legislatures cannot agree with the United States in regards to these issues, they can't agree with the U.S. Constitution, I should say, it is a responsibility of the judicial branch to advocate on behalf of the people and the Constitution by clarifying, voiding, and sometimes creating certain laws that conflict with the Constitution. Therefore, it became the responsibility of the Supreme Court, in a sense, to legislate on behalf of the Constitution and the people, specifically the Equal Protection Clause of the 14th Amendment, which the U.S. Supreme Court, in this case, used to decide that same-sex couples are entitled to the same state benefits that opposite-sex couples enjoy. And you can arguably list a long list on either side for pros and cons to judicial lawmaking, but I kind of focus on a handful for each side. Some of the pros to the system of judicial lawmaking in the United States include that the Supreme Court can right a wrong or fix a wrong. This was the case in Obergefell versus Hodges. The Supreme Court took the case due to its nexus and conflict with the Constitution, and ultimately I feel the decision was correct to establish that the Constitution allows for any person to marry the partner they choose. Another pro is that judicial lawmaking is a recourse to protect the Constitution. The Supreme Court is tasked with being the protectors of the Constitution, if you think about it, and oftentimes when asked to defend the Constitution, the result is creating a law. And then judicial lawmaking can be viewed as a last line of defense. When the states or one of the other three branches of government get it wrong, the Supreme Court is the last line of defense to fixing an issue, and oftentimes that includes judicial lawmaking. And some of the cons, the court does not always get it right, and this is a huge one. There has been countless cases where the Supreme Court has irrefutably decided incorrectly. Fortunately, many of these have been corrected, yet much damage was done over long periods of time. It can accurately be stated that the Supreme Court decisions are a lot of times politically motivated. Although the Supreme Court appointments are lifetime appointments, they don't risk being fired or anything like that by the political decisions, by the decisions that they make based on the political climate of the nation. Arguably, there's a sense of loyalty to those that selected them for their position, and their voting record reflects that. And we can get into the chicken or the egg. Did a president nominate somebody because of the way they typically had voted, or is the justice kind of voting a certain way to kind of remain loyal to the party or the person who selected him for the position. And finally, if the Supreme Court gets a decision wrong, their decision impacts the entire nation, not just a state, for example. And these decisions can be very long-lasting. Often it can take decades or longer to reverse a decision. And that's all I have. Thank you for listening.